can you imagine if you were like, well, of course you have a right to freedom of speech, but not right now,
Right. You don't have
right?
an immediate right to freedom of speech.
That thing you want to say, you sit on it for a couple days.
You want to
Maybe the
vote on
government will take a look at it, government will decide, make sure you're cool to say it. Then, but that's not a limitation, is it, Richard?
no.
We are the Armed Attorneys. Today we are talking about the latest anti-Second Amendment laws to work their way up through the court system, undergoing some Bruin analysis. This time, high capacity magazine bans and waiting periods for firearm purchases. We're going to talk about what are arms under the Second Amendment, what is in common use and is that totally meaningless, and where do we go from here. But before we get started, show your support for the Second Amendment by hitting the like button.
And so I think, we see a lot of gun challenges going on across the United States. They're attempting to apply, some not so faithfully, the standards that were laid out in New York State Rifle and Pistol Association v. Bruin, and make it mesh with precedent from maybe less relevant times, think 1930s. And so, we have to kind of big picture this just for a moment so we know what the court's footing is on. And we're looking at this case. It's going to be in the Second Circuit Court of Appeals. This is New York, Vermont, kind of the usual suspects. So not a good start. But, we look at the standard in New York State Rifle and Pistol Association v. Bruin. We look at the text of the Second Amendment. It's informed by history and tradition. We look at, gun laws are facially unconstitutional. Then, if it's implicated, then we look, hey, history, tradition, is this something that would have been regulated at the time of the adoption of the Second Amendment in 1791? And if the answer is no, the government loses, right? So we should have the deck kind of stacked in our favor, but I don't see that happening.
Wouldn't that be a great test were it faithfully applied?
Yeah.
Wouldn't it?
Wouldn't it?
Wouldn't it? So, what we have here are challenges to Vermont's laws, a high capacity magazine ban. And before the keyboards start clicking, I am aware that these are commonly referred to as standard capacity magazines, but Vermont, this is what they categorize. A long gun magazine of more than 10 rounds, they say, is high capacity, and a handgun magazine of more than 15 rounds is high capacity, and therefore regulated out of existence, essentially, under this law, which is insanity. Now, we also have the waiting period issue, which in Vermont is apparently 72 hours. I thought Vermont was, is New Hampshire the free one?
Yeah, that's the free one.
Okay, so Vermont's
Not,
not.
yeah.
Vermont's the weirdo place with the Bernie Sanders
Sure.
and the frenetic stuff. Okay, I don't know. So, all right, here we go. Here we go, Vermont. Sorry. But so we have these laws that are frankly fairly shocking to me. And we have a district court in Vermont, smacking down the Second Amendment. And what reasoning do they use for that?
Well, it's not good.
No.
It's not good reasoning, but I'm going to throw some numbers out just in case people want to go and check these stuff out. So their high capacity magazine ban is Vermont statutes annotated. It's 13, section 4021, and their waiting period 13 Vermont statutes annotated, section 4019A. So those are the two laws if you wanted to go check these out. And this is the Vermont Federation of Sportsmen versus Matthew Birmingham. If you want to look at this case, it's 223 CV 710. We'll have it all linked in the description below. But the court's reasoning on both of these things fall under kind of two things. And this case was filed back in 2023. They say, hey, guess what? We found historic analogs. I think that's really, they apply. They cite Bruin all over. It is all over this 88-page opinion. I mean, that's a very long opinion. Bruin is cited everywhere, and they say, yeah, these are fine. These are analogous. And what they consider a high-capacity magazine for rifles is anything that holds more than 10 cartridges.
Yes.
That is a small.
Yes, that is insane.
That's a New Jersey small.
Mm-hmm. So, I mean, but sorry, I like that. But so we have actually, so yes, there is a Bruin analysis here, but I think in anticipation of all of the appellate challenges that are to come, the court actually does two things, and this was very clever. If you're an anti-gunner, you're going to be very happy about this. Is that the first analysis is magazines aren't arms.
Yep.
Magazines aren't arms,
Exactly right. Yeah, they
right?
completely, and that's the strategy when you
Mm-hmm.
when Bruin is not going to land in your favor, you have to completely sidestep it.
Yes. And so, step one is this isn't a Bruin analysis to begin with.
But if it is an arm, it's not in common use.
If it is an arm, it's not in common use. It is not necessary for self defense, which, like, again, like I would beg to differ.
But also, if it is Second Amendment, if it is in common use, then we also found an analog.
Right. Yeah, exactly. And really, and this is what lawyers do, right? Lawyers argue in the alternative, and this court has ruled essentially in the alternative, and that's just like lawyer CYA for basically like you throw all the spaghetti at the wall and you see what sticks, right?
Yeah, I mean, I was just reading a different case this morning where they overturned. It was a guy who was charged with possession of a prohibited weapon. They overturned it because they didn't have basis for the stop. We just talked about that just a few weeks ago, and they said we didn't even look at the Second Amendment because it wasn't argued. So it's like, this is why you CYA.
Yes, you see why you do. But so the court is doing that too. Normally the lawyers do that. The court makes a decision. Here the court is doing that in anticipation of the appellate challenges to come. So we have a very frustrating analysis on the magazine capacity limits. But I would say for me equally frustrating on waiting periods because essentially the court just decides without, I mean, for me, sufficient reasoning that you never have a right to an immediate gun in this country.
Yeah, so I mean, but we look, is getting transfer of a firearm, is that implicated by the Second Amendment? Yes,
Yes.
clearly yes. Then we should say, hey, guess what? This is facially unconstitutional. Then burden shifts to government to show based on the text of the Second Amendment. There's nothing in the Second Amendment about waiting periods. Well, then we need to look at history and tradition. Is this something that's regulated? For this second issue, when we'll go back to mags for in a little bit, but for this second issue, they cite all modern regulation.
Mm-hmm.
There's no hey, colonial error XYZ. I mean, they do. They talk about colonial era stuff that has nothing to do with this, but there's no analog to this.
There is no analog to this. And, again, and this is, I know, a soapbox that everyone listening can get on with me, so I won't belabor the point. But can you imagine if you were like, well, of course you have a right to freedom of speech, but not right now,
Right. You don't have
right?
an immediate right to freedom of speech.
That thing you want to say, you sit on it for a couple days.
You want to
Maybe the
vote on
government will take a look at it, government will decide, make sure you're cool to say it. Then, but that's not a limitation, is it, Richard?
no.
It just is no, it's just insanity. It is insanity and it is a disfavored right and it is, and here we are because the judge can make the call and the people suffer until and unless higher courts undo that call. And here we are.
But I want to go back to magazines just for a second because I will say they do a not a good job, but a better job saying, hey, and then they at least pull some colonial era laws in saying, hey, look, we had prohibitions on the way that you store black powder.
Yeah.
And that's the analogy that they draw here. I think that is one of the weakest analogies I've ever seen.
Well, it is because there's not a real one.
No.
So you do I guess if you're just making it up, you do the best that you can, but it should not hold water. If this were happening in the Fifth Circuit, I can guarantee it would go up to the Fifth Circuit, and the Fifth Circuit would say, but again, as we spoke to earlier, where is it going?
Second Circuit.
Second Circuit's going to be like,
Yeah. Cha-ching.
good enough for
High
us.
five, Ninth Circuit. But the
High-fiving over the country, the second and the ninth. They're like,
it's a good mental
oh,
image.
it is a good mental image.
But where were we in this case? Well, the court didn't give them a temporary restraining order. That's where they would have held the law back from going into effect or being enforced while the thing was litigated. They were at the preliminary injunction stage. The court says, hey, guess what? You're not likely to succeed on the merits. They do all this balancing and policy analysis and ultimately deny plaintiffs relief here. And so the step after this, I mean, this case has been going on since December 18th, 2023. You see how slow these things move. They asked to have an expedited trial. The court was like, no, you don't get any special treatment. So what will happen next? This will go on to the permanent injunction phase. We have to actually have a trial on the merits. Then the court will rule on it. It'll go to the Second Circuit, which I will say, it's actually important to have a circuit rule against the Second Amendment under these circumstances. And why would that be?
Well, That's how we get it to the place it needs to go.
Yeah, we got to get that sweet circuit split.
Yep. So circuit splits are just SCOTUS candy. They eat circuit splits for
I'm
breakfast.
not aware, and I would be interested if y'all are aware of this in a gun-friendly circuit, if there is a magazine ban floating out there in order to get this thing challenged. That's something I don't know the answer to.
I don't know, but we need it. We need it
Come on,
because
Texas, pass a magazine ban. No, that's
don't
not
quote him on that.
That's not what. No, a complete joke, and that's not what we're saying. But in order for this to get to the Supreme Court, we obviously need circuits to disagree on this stuff.
That's the best way. It's not the only way, but that's
Right.
the best way. So yes, and when we'll see about it, right? But it is unfortunate for the people of Vermont because this will be an extraordinarily long wait. And Lord knows that the Supreme Court has so many gun law cases that need to be addressed that are in line before this one because rather than responding to Bruin as like I think the country should have, which is to say, this is the new law of the land. Let us act accordingly. All of the blue states and blue cities where there's no preemption, right? And they can pass their own laws, said, oh, that's the new law of the land. Like, I'll blur that for YouTube probably.
Yes.
But I mean, it was just, I mean, it is a blatant thumbing the nose at Bruin, and that the only way we resolve that is by sending it all back up through the court system and ultimately maybe all the way back up to Supreme Court. So they've got their work cut out for them.
And the expedited path is maybe it gets tagged on to one of these assault weapon bans. Maybe this gets brought up in the same kind of discussion. But we also need some clarification on the common use issue. I will say, we have Miller, our 1939 case, where they say, guess what? We have only firearms that are in common use are protected by the Second Amendment. I mean,
You got Heller, which
that's ultimately that's ultimately one of the
expounds on it,
one of the holdings. But we see courts where things are. I mean, at what point do we come into common use? I can't think of anything in more common use than standard capacity magazines. And if they're going to wiggle their way out of that, then I don't know where we go.
I don't know where we go.
But we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And let us know if you are ready to give up your factory magazines. And don't miss us every Monday, Wednesday, and Friday at 5 p.m. Until next time, we're the Arms Attorneys.